Is your license suspended immediately after DUI in Indiana? Well, the answer can get a little tricky. That is a classic lawyer response, and I get it. But it's not as easy as you might think. The way the law in Indiana is written, a person's driver's license should not be suspended unless they blew at the station or the blood out of their arm is 0.08 or greater. That's the law. They should not lose their license unless one of those two things is present. Now, if the person refused the breathalyzer at the station or they refused the blood out of their arm and the officer had to get a warrant, or the officer didn't get a warrant, but they refused it, well, then their license is going to be suspended for a refusal. But that's not because of the DUI. So it gets kind of weird, right? But the reality is, if you submitted to the breath test at the station, if you submitted to the blood test at the hospital or the side of the road in some counties like Hamilton, how weird is that? Oh, do your blood at the side of the road. But your license should only be suspended if the result is back and it's 0.08 or greater. And then it shouldn't be suspended until the first hearing with the judge. Now think about that. That's fair. How would a person know their license is suspended unless they've had a hearing with a judge or the person had an attorney and the attorney waived that first hearing and the judge suspended it at that waiver hearing? But the reality is you should not lose your license unless you blew into the machine or your blood came back 0.08 or greater. Now, if you did blow into the machine or your blood came back 0.08 or greater, or you refused, well then, your license is going to be suspended at that first court hearing. Not necessarily right when you leave jail, because again, how is a person supposed to have notice unless it happens at the initial hearing? Or at least have an attorney, and the attorney waived it. Now, this is all over the place. There are some counties in Indiana that say, hey, you know what? If the officer had probable cause to get your blood or breath, even if you submitted, even if we're waiting for those results, suspended. There are some judges that will say, hey, you know what? We're going to suspend it before the initial hearing because I want to make sure that you know you're not supposed to be driving. It doesn't really do anything because you don't really know you're not supposed to be driving unless you're checking your B&V every 5 minutes. But it can get complicated whether or not your license is suspended immediately after a DUI. So I encourage everybody, if you're questioning whether or not your license is suspended immediately after a DUI, here's a couple of different things. Go to Indiana B&V. Everyone should have a log-on and password. Check. What does it say? Status. Now, if a judge has told you do not drive as a condition of your bond, well, it doesn't really matter what the online says because a judge told you not to drive. We see that in some counties where judges try to get very hands-on with these type cases, and they say that do not drive as a condition of your bond. I don't care what the B&V says. I'll catch you driving, contempt of court, or worse. We don't want to make judges mad. You don't want to do that. But absent being told that your license is suspended by a judge or your attorney telling you your license is suspended, go to the Indiana B&V website, log on. It'll say status. If it says active, you can drive. Now, that status could change very quickly, so you want to check that often if you get a DUI and you're wondering about your license status. But even easier than that, give an attorney a call. Don't just call a random attorney out of the phone book. Call an attorney that actually does DUI defense, because a lot of attorneys that I talk to, they don't understand how a license is affected by a DUI. And it sounds crazy, right? We're attorneys, we're supposed to know. But a DUI is a very nuanced, can't really say specialized. I can't say I'm a DUI specialist. There's rules against that. So I'm not going to say I'm a DUI specialist. But I have spent a lot of time defending DUIs. And I see a lot of the same issues with the driver's license. And so call me or call at least somebody like me who's experienced in DUI that can answer your questions. When you're dealing with DUIs, you don't want someone that shoots from the hip. Well, here's what it should be. You want someone who knows what they're talking about. You just do, because one of the quickest ways I've seen people make judges mad, I would never say a judge gets pissed off. That's very sophisticated. One of the ways that I see judges get upset is when people are not supposed to be driving because of a DUI suspension and they get caught driving. That is a quick way to make the judge mad at you, because most judges look at that as a person not having respect for the court. And I tell you what, judges love the idea and the concept that, hey, I'm in charge of this proceeding. You need to respect my authority. And it's problematic when judges perceive somebody as not respecting the authority. And well, when I say problematic, what I really mean is not going to work out in your benefit. So if you have any questions about DUIs and license suspension, give me a call, 317-632-3642. I'll tell you what, one of my things that I love is getting people back on the road, because I recognize we live in Indiana. We don't live in Chicago or New York. Not L trains going everywhere. Buses, there's a few buses, but not enough, and probably not where I'm going to go. So I want to get my clients back on the road because I want them to be able to work. I want them to be able to do the things they need to do for their family. But we have to do it in the right way. Again, give me a call, 317-632-3642. I'd love to talk to you about your situation. Most importantly, though, remember to always plead the fifth.